Jurisprudence is so important chapter as per uh, the philosophical norms, as per the thinkers' norms. So here we have a statement: jurisprudence is the knowledge of things human and divine, the science of just and unjust. So this statement has been said by whom? So the normal Keaton, Savigny, and Alpian. Alpian is the right appropriate answer. There are many thinkers which stated many more things for jurisprudence, and especially for the definition of jurisprudence. The jurisprudence, this statement, Alpian was the great Roman jurist, defined jurisprudence as the knowledge of things divine and humans, the science of just and unjust. In other words, the science of right or wrong. Just and unjust means right and wrong. So Alpian was among the first to give a formal definition of jurisprudence, and he formally just gave the definition of jurisprudence, highlights the scientific study of jurisprudence. Incorporating the term observation signifies methodology that gives the entire definition a scientific character. So that was Alpian who said that statement. We move to another question from jurisprudence. Who said the jurisprudence is the eye of law? It means eye of law. What is the exact meaning of eye of law? Eye of law means how the decision might be given to people. So there be a eye of law, there be the medium of thought, the medium of philosophy. So the person was, who said that? So the person was Lasky. H.J.S. Lasky. He was an English political theorist, English means from Britain, and economist. Lasky saw jurisprudence as the eye of the law. It relates to the functioning of the eye that helps in seeing the environment. Similarly, it helps in giving a new understanding of law, and similarly, it helps the people to understand through the philosophy of that particular thing. So that was the person Lasky who gave this statement. Who among the following looks at jurisprudence as the system of rules? When we say the system and rule, both are two things, the system and rule. It means there is a system of rule. So it is not matter whether things are right or wrong, but we are talking about the system of rule. So system of rule mean there are some rules which enable the thing as a system. So who stated this? So that was the person Austin Hart, Salmond or Holland. So as a system of rules is stated by Hart. Professor H.L.A. Hart. H.L.A. Hart. He stated this. He may be regarded as the leading contemporary representative of British positivism. He wrote in influential book, The Concept of Law. He wrote that book, The Concept of Law. Sorry. The Concept Law. He criticized Austin theory. According to Hart, law is a system of social rules. Rules which sprung from social pressure, which acquire the character of legal rules. That is the thing. And law, law is a body of publicly ascertainable rules. Law, according to Hart, is equivalent to a legal system. So that was the thing which was stated by Hart, H-L-A-R. So answer is Hart. As you know, there were many philosophers who gave many statements regarding jurisprudence. So next question is, the theory of categorical imperative was propounded by. Categorical imperative means what? There were some categories. There were some categories. There were some categories in sense. In many sense, there are always categories in societies, in system. So when we talk about categories, it means there are some imperatives, some directions according to many category, many persons from categories. So that was German jurist Immanuel Kant. Immanuel Kant was German jurist. He propounded his famous theory of categorical imperative in this classical work. He critique on pure reason. His theory was derived from Rousseau's theory of general will. You know, Rousseau stated the general will, the will of the people. And embodies two principles. One, a man is expected to act in such a way that he is guided by the dictates of his own conscience, human rights of its determination. And second is autonomy of will, implying an action emanating from reason. So there were two things. So that person was Immanuel Kant, who propounded this theory, categorical imperatives. We move to another question. Who described jurisprudence as lawyer's extraversion? Lawyer's extraversion. Lawyer's extraversion. Nowadays, it is so necessary for studying jurisprudence. You know that you may be a advocate as well. So that was the thing. Now, who might be described? To Professor Julius Stone. Professor Julius Stone. Julius Stone, in his book Legal System and Lawyers' Reasoning and the Province and Functions of Law, said jurisprudence as lawyer's extraversion. It means that it is a lawyer's exam, exam that the perception, the ideas, the techniques of the law in the light right from present knowledge. So that was the thing which stated by Julius Stone. It means you have to remember the name of the book, Legal System and Lawyer's Reason. That there was a book. So we move to question number 6. The province and functions of law named book was written by. The province and function of law. Earlier, before this question, I described this thing. So who might be a person, suitable person? You know Julius Stone. He wrote 2 books which I explained. So that was the thing. The province and function of law. Law as logic, law as justice, law as social control. That all was written by Julius Stone. In this book, he presents his view on the proper meaning of the word jurisprudence and the the scope of the subject. He also described jurisprudence is lawyer's extraversion in the sense that whatever be the branch of law, for instance, environment law, human law, etc., etc. So any general concept like citizenship, the law does not confine itself to its domain or subject matter itself, and it goes extra mile while making an inquiry into the set concept of branch. So that was the thing, so both the books was written by that person, Julius Stone. So now we move to another question, that is question number 7. Law is uncertain and certainty of law is a legal myth. This is the statement of whom? Jerome Frank. Jerome Frank. Jerome Frank was the proponent of the American school of realism and played an important role in the advancement of American legal realism. Among his most renowned and controversial work is Law and the Modern Mind, in which he introduced the notion of what? Notion of a legal myth. He claimed that law is uncertain and certainty of law is a legal myth. His other book was as the Courts of Trial. Courts on Trial. Courts on Trial. He wrote that book also. So that was the question number 7. We move to another question, question number 8. Jurisprudence is the scientific synthesis of essential principles of law. So that was said by Allen, Holland, Benathan, Austin. Many more persons are there. So who might be wrote this book? Jurisprudence is the scientific synthesis of essential principles of law. That was said by whom? So that person was Allen. His name was C.K. Allen. He was a great jurist of analytical schools of jurisprudence. He referred to analytical jurisprudence as imperative jurisprudence and stated that jurisprudence is the scientific synthesis of essential principles of law. It seeks to define all laws, class by all laws, discover the essential feature of every law, and establish a yardstick by which all laws can be measured. So that was the person, Allen, C.K. Allen. So he was a greatest jurist of analytical school. He stated this. So we move another question, question number 9. Who among the following said the witnesses are eyes and ears of justice? Now we are talking about the evidences. So witnesses as eye and ears of justice. Eyes and ears of justice. It means you must have the both evidences, which might be seen, which might be heard according to that particular time. So that person was Jeremy Bentham. Jeremy Bentham said that witnesses are the eyes and ears of justice, right? Kelson called law the science of standards, the Fuller of opinion that a degree of morality is necessary for the existence of a society, right? And Holland stated that international law is always the vanishing point of jurisprudence. So that was the statement said by Bentham. The law means the entire body of rules in a state, a particular law, the rules of morality, the rules of natural justice. So how would you define the entire body of rules in a state? The law means state is always a thing which might be validated by the state. The state is necessary. So when we say the law means, so state must be there. So the entire body of rules in a state, Because without the state, it means the power of making law is validated by the state. So, under the state there are many institutions. So, entire body of the rules in a state, this is the real law means. Because in state, parliament make law, the legislative assemblies make law, that happens in the state. So, this might be the right answer, right? So, next question is, we move to question number 11. In which of the following the idea of natural law first appeared? When we talk about the natural law, what is the exact meaning of the idea of natural law? That was initially defined by ancient Greek philosophers such as Aristotle and the Plato. The basic tenets of natural law, are number one, law is related of justice, reason, human nature, and ethics. Two, rules of human conduct emanate from a supreme authority and are binding on all men everywhere. The third is natural law is opposed to written law. The former is wise, the latter is arbitrary. And fourth, a law is an order of things. It demands equality among all the men. So that was firstly described by the Greek thinker Aristotle and Plato. So there are many more meanings of natural law. Natural law means law, as the nature takes every person equal, so justice should be equal to all. We are naturally similar to every person. Next question is question number 12. The basis of natural law was laid by Heraclitus, Aristotle, Austin, and Hobbes. Right? Hercules. So, who might be the right person? The basis of, as I described in question number 11, who described the natural law? That was the first person. Those were Greek thinkers. So here you you get the Greek thinkers laid the basic of natural law and developed its essential feature. And Heraclitus was among the first to do so. He found it in the rhythm of events which he termed destiny, order, on a reason of world. So that was the Heraclitus, right? That definition was based on natural law. Now, which one of the following doctrines is not associated with natural law thinking? It means doctrine of due process, doctrine of substituted security, doctrine of bias, doctrine of reasonableness. So, there is a doctrine which is not associated with natural law thinking. Which means how we describe the natural law, that this doctrine is just the opposite doctrine of that particular law. So, the right answer is the doctrine of substituted security. How? The doctrine of due process, bias, and reasonable are associated with natural law. Due process, biasness, and reasonableness is associated with natural law thinking. In the Constitution of India, a large number of principles are based on the theory of natural law, such as fundamental rights, the right to equality, and the supremacy of the judiciary. The doctrine of substituted security is not related of natural law thinking. So this is the right question. We move to next question, question number 14. Which one of the following juries was hostile to the natural school law? So this is the next question. I am talking about the juries which was hostile by the natural school law. So Many more persons were there. Immanuel Kant, Stammler, and John Rawls are the main jurist of natural law school, right? Stammler, John Rawls, Immanuel Kant, these three persons are the main jurist of the natural law school. Bentham belongs to the analytical schools of jurisprudence. Jeremy Bentham. Jeremy Bentham belonged to the analytical school of jurisprudence. According to Jeremy Bentham, natural law is nothing but a phrase. He criticized natural law and called it a nonsense upon stilts. So Austin was also against the natural law theory, and according to him, it was nothing, right? So we move to another question, question number 15. Who among the following is critic of natural law? I described many more names who were from natural law, who were against the natural law. So now we get again that person, Jeremy Bentham. You know, who among the following is critic of natural law? Jeremy Bentham criticized the natural law. You know, he took it as nothing. He took it as a phrase. So next question is question number 16. Which one of the following jurists belong to ancient theory of natural law? So many more persons are here who belong to the theories of natural law. It means they believed in natural law. Who might be that person? Very easy. Socrates. Socrates is the foremost among the followers of ancient theory of natural law. He was a rational thinker and he was an also enlightened person who believed in human insight. He believed that morality is the higher law. Morality is higher law. According to him, man has his own insight which help him to know what is good, what is bad. Thus, man should act in accordance with this, right? With this insight. When we move to another question, question number 17, the theoretic character of natural law was given by whom? The theoretical character of Plato, Augustine, Aristotle, Thomas Aquinas. Who was the person who believed this theory? According to whom? According to whom? Right? According to whom the natural law was associated with the eternal law of God. He believed, who believed? He believed that what exists in human beings is not the eternal law itself, but a certain impression of notion of the eternal law. So that was the person Saint Augustine. Saint Augustine believed there were four kinds of law. The first law was eternal law, which is God. Second, natural law, which is a notion and an aspect of God's spiritual image. Third, temporal law, where certain laws change over time due to different circumstances. And finally, divine law, which is the law passed by the God. So, Saint Augustine was the person who described this law. So again, we have to move on certain questions. We'll try to find that previous previous thing. So we lost that particular question answer series. Try to find out. No, not getting. So it's all and to the all question answer. We'll take it tomorrow as well. After 16, 17 questions, we had to solve at least 30 questions, but the things disappeared. So we'll meet tomorrow at 8 p.m. Until then, thank you. Goodbye.